Foreign jurisdiction clauses are clauses declaring a transaction to be governed under law of a particular country. Facts of present case. COVID-19 has been declared as a pandemic.
Sarah owns a logistic company in Malaysia to transport international goods.
Eric owns Pharma Liga that produces and distributes medicines. Eric's main office is in Malaysia, but he also have offices in USA and Japan. Eric found a COVID-19 vaccine to cure the pandemic.
Sarah approached Eric to transport the vaccines, but Eric was hesitant because the vaccines have to be carefully stored under -400 degrees Celsius.
Sarah reassured she has the facilities, so Eric agreed to let her transport the vaccines, and the contract was made through a lawyer. The contract contains a clause which says, if any breach arises, the dispute will be discussed in courts of USA.
Sarah's team transported the vaccines by sea and first dispatched in Japan.
Eric discovered the vaccines were defective because Sarah stored them under -100 degrees Celsius instead. So he filed a writ of summon in court of USA. Ship stopped at Japan.
Sarah was at Malaysia at that time. She argued the case should be conducted in Malaysia, where the vaccines were first dispatched from.
Eric was in Korea at that time.
Sarah also contended that it will save costs of proceedings, as both parties and ships are closer to Malaysia compared to USA.
The issue is which jurisdiction should this case be brought forward to. The LIA3012 case provided factors on how courts grant stay application in foreign jurisdiction clause. First factor is, in what country the evidence on the issue is situated, or more readily available, and effect of that on relative convenience and expense of trial between English and foreign courts. Next is whether the law of foreign country applies, and if so, whether it differs from English law in any material aspect. Next, with what country either party is connected to and how closely. In addition, whether the defendants genuinely desire trial in the foreign country or are only seeking procedural advantages. Lastly, whether the plaintiffs would be prejudiced having to sue in foreign court, i.e., for political, religious, or other reasons unlikely to get a fair trial. Next, the Femarn case explains the effect of foreign jurisdiction clause in contract. First is that any disputes are to be judged in a foreign tribunal, is subject to overriding principle that no one can oust the jurisdiction of courts in a matter properly belonging to them. Court has discretion to consider matters of convenience for stay application by determining which country is the dispute most closely connected to, such as availability of witnesses, frequency of ship visits, and many more.
Third, Sabah Gas Industries and Trans-Samudera Lines. Reference was made to decision of Federal Court in Globus Shipping Trading and Taipang Textiles, that Malaysian court has the discretion to adjudicate a case that is within its jurisdiction, even though the parties had agreed to refer the disputes to a foreign court. The court cited the principles under the LIA3012 and held in favor of defendant that 1. The arbitration proceedings was in accordance to the contract. 2. Plaintiff had failed to establish fraud. And 3. Plaintiff's claim do not merit any adjudication by this court on the basis of the claim fails as no cause of action or substance proved. Next, Inter-Maritime Management and Kaitai Timber. The Femarn and the LIA3012 were considered in this case. The judge held that, by acting in obedience to binding precedent, there ought not to be a stay. The judge took these facts into consideration, and held that trial in Malaysia will be less expensive and more convenient, and the court was aware that the respondent bears the burden to produce strong grounds to displace the forum selected by the parties. Now, the application to this present situation. In our current scenario, the principle in the case of inter-maritime management can be applied. The judge in inter-maritime applied the Femarn, and decided that trial in this country will be less expensive and more convenient, and that Malaysian jurisdiction is better for these reasons.
Similarly, taking the reasons of cost and convenience into account, Sarah's argument is valid, that the case should be conducted in Malaysia as that is where the vaccines were dispatched from in the first place. This proves that the case is mostly connected to Malaysia in terms of facts and conveniences, as compared to the USA.
Also, Mr. Eric would not be prejudiced if the proceeding took place in either of the courts. Therefore, conducting the case in Malaysia seems to be more appropriate. In conclusion,
by applying the principle of foreign jurisdiction clauses in the Fimarns case, where the Malaysia court would be more suitable to continue the proceeding in, Sarah would most probably succeed in her plea.
that is the end of the video. Thank you for listening.